Hi, all. This is Claire Thomas. It is April 7th, 2020. And for our immigration update today, I'm here to discuss immigrant eligibility for a recovery rebate under the Federal CARES Act. So let's begin. What is the CARES Act? This is the stimulus package that President Trump signed into law on March 27, 2020. Its official name is the Coronavirus Aid, Relief, and Economic Security, or CARES Act, and it is a $2 trillion economic recovery package. The package offers relief to state and local governments, individuals, small and large businesses, and hospitals affected by COVID 19. And in particular, it provides for the issuance of one time payments called recovery rebates, or more commonly known as stimulus checks, to help individuals recover from the economic impacts of the COVID 19 pandemic. So, let us begin in talking about how much is the recovery rebate, who is eligible, and how does immigration status come into play. So, how much is the recovery rebate? So, this is all on the IRS website, but effectively it's looking at eligible individuals with an adjusted gross income up to $75,000 can receive a one-time payment of $1,200. Married couples filing a joint tax return are eligible to receive a payment of $2,400 as long as their adjusted gross income is less than $150,000. And eligible individuals can also receive an additional $500 for each eligible child under the age of 17. The recovery rebate is to be automatically advanced to eligible individuals in 2020 based on their 2019 federal income tax returns. For individuals who did not file a 2019 return, the rebate is to be automatically advanced based on the 2018 tax return information. So, who is eligible? So, only individuals with valid social security numbers and people who qualify as, quote, resident aliens as defined by the IRS are eligible to receive the payment. Note that the IRS does use the terminology resident aliens in their statutes. And so, to mirror the statute, that is the language that I'm going to be using in this slideshow presentation. But please don't think that in real life I go around using this language. So, non US citizens are considered to be, quote, non resident aliens by the IRS unless they can meet one of two tests that are set forward by the IRS in its guidelines. Those tests are the green card test and the substantial presence test. So, let's dive a little bit deeper into those. The green card test. So, lawful permanent residents or green card holders in the United States are considered, quote, resident aliens if they were lawful permanent residents at any time during the calendar year. This is known as the green card test. And so these folks, lawful permanent residents, continue to have their resident status under this test unless they voluntarily renounce and abandon their status in writing. Their immigrant status is administratively terminated by immigration, usually the United States Citizenship and Immigration Services, or USCIS, or their status is judicially terminated by a federal court or immigration court. The other test that the IRS has is the substantial presence test. In this test, a foreign national or non US citizen is considered to be a, quote, resident alien if they meet the substantial presence test for the calendar year. To meet this test, an individual must have been physically present in the United States for a designated minimum threshold period outlined by the IRS. And all that is defined by the IRS. You can find more information on its website or, of course, in the regulations if you want to read those. Note that the IRS exempts certain non immigrant visa statuses from this physical presence calculation, and those are individuals who are temporarily present in the United States on non immigrant visas, including F, J, M, or Q. So, most work authorized immigration statuses, such as H 1B, L 1, O 1, and TN, are not exempted, and thus those holders may be able to meet the substantial presence test. Let's do a note about ITINs. ITINs are effectively individual taxpayer identification numbers, and those are often used by folks who are not eligible for a Social Security number. So importantly, those who file their taxes using an ITIN are not eligible for the recovery rebate. The CARES Act also denies the rebate to an eligible individual with a Social Security number if that individual filed a joint return with a spouse who has an ITIN or filed a return with a qualifying child who has an ITIN. There's a limited exception for adopted children and military families. So, from a practical standpoint, this means that folks who many H-1B and other work authorized non immigrants will not be eligible for this recovery rebate if they've filed joint tax returns with a spouse who doesn't have a Social Security number. This is particularly problematic for the large number of H-1B workers whose spouses, who are then in the H-4 category, are not eligible to receive Social Security numbers. Another common question is about public charge, and will receiving a recovery rebate impact a person's immigration application under this new public charge rule? So it's important to note that recovery rebates are structured as automatically advanced tax credits to be dispersed by the U.S. Treasury Department. So the Department of Homeland Security's final rule on inadmissibility on public charge ground is actually clear that tax credits are not to be taken into account for the purpose of a public charge determination. DHS indicates in its final rule that only public benefits as defined, and then it lists a certain section of the Code of Federal Regulations, 8 CFR 212.21b, will be considered in the public charge inadmissibility determination. These public benefits include means-tested programs like Medicaid and cash assistance for income maintenance. And interestingly, that section of the federal regulations indicates that cash assistance for income maintenance does not include tax credits. Also, in the USCIS policy manual, it clearly states that tax credits are not considered public benefits in a public charge inadmissibility determination. And finally, in the State Department's interim final rule and Foreign Affairs manual, for those that are consular processing, those align with the Department of Homeland Security's final rule in that a public benefit is cash assistance and that income maintenance does not include tax credits. So finally, for more information on this topic, please check out these two resources. One is by the Organization Protecting Immigrant Families and the other by the National Immigration Law Center. These links should be active, and so you can click on them for PDFs and websites from these organizations in order to find out more about immigrant impacts and the CARES Act. Thanks all.